Hi guys. So in this session, I'm going to walk you through some of the most important Supreme Court judgments of this year, 2025, the cases that will not only shape the legal landscape, but again, it is very much important for UPSC aspirants, even judiciary aspirants, and anyone who's trying to understand the evolution of constitutional law in India. So this one, I'm sure that these judgments are actually what's shaping the legal landscape for the upcoming years also, right? So the judgments basically dealing with fundamental rights, forced scientific tests also, and then powers of the governor and the president, legislative process and the constitutional delays, arbitration and modification of arbitral awards, and then property law and the meaning of valid ownerships. So each of these cases will be broken down in a way that you can understand, you can remember, and you can reproduce if it is asked in exam. Especially some of them are very relevant when it comes to polity test, some of them in ethics also, like this fundamental rights and the forced scientific test, right? Similar, that's again, powers of the governor and president. All these we'll discuss. Let's start with the first one. See, Amlesh Kumar versus State of Bihar, 2025. The core theme here is about narco-analysis, self-incrimination, and Article 20 and 21. So you know what you mean by self-incrimination. So this case, in fact, revisit a long-standing debate that whether the police can conduct a narco-analysis test without the consent of the accused, right? So this is actually the question here. Now, the facts of the case, if I want to discuss, the accused was charged with dowry harassment and, disappearance of his life. And during the bail hearing, the police requested narco-analysis test and the High Court allowed the test. And the accused basically appealed to the Supreme Court, claiming that such a test will violate Article 20, Clause 3, right? That's his right against self-incrimination. And also Article 21, that's personal liberty. And he relied on the landmark judgment of Selvi versus State of Karnataka, 2010 judgment. Now, what did the Supreme Court decide in 2025? See, the court laid down 5 important principles. This is very important. So first one, no involuntary narco test. It's unconstitutional. So conducting narco analysis or polygraph or brain mapping without consent will violate Article 20, Clause 3, which means no person can be compelled to be witness against themselves. No self-incrimination. Also violating Article 21, that's the protection of personal liberty. So that basically reinforcing the Selvi judgment, right? And also the statements made during the test are not admissible. Any confession or any statements made under the influence of narco drugs cannot be used as evidence. Just like, you give confession to the police, which is not admissible in the court. Similarly here also. Third one, new facts discovered from the test are admissible. For example, if the accused under the narco saying, I threw the knife on the old well, or this, I might have murdered and the weapon used is a knife and I took it and, disposed it in the well or disposed it in the river. And the police actually recover that. This is exactly what happens with the confession given to the police also. The confession is not valid, but any such recovery which is happening based on that confession is valid. So that recovery, you go and recover under the narco analysis, you're saying something. Now the police go and recover that. That is admissible under Section 27 of the Evidence Act. I hope you got my point. It is very similar. There is nothing changed here. Also, fourth one, the test results cannot be sole basis for the conviction. You cannot convict someone only because of what they said during the narco test. And fifth one, accused may voluntarily request the test, but it is not an absolute right of the accused also. See, an accused person can ask for narco analysis to prove his innocence, but this is not an enforceable right, right? So the court will examine the facts before granting the permission. So these are the 5 conditions which are laid down by the Supreme Court. And why this case is important for UPSC? Because this is strengthening 3 major principles: human dignity under Article 21, right against self-incrimination, 20 Clause 3, and the boundary between scientific investigation on one side and personal liberty on the other side. So this judgment, again, I'm sure that it will be quoted for years in the upcoming time. Now, case 2. Let's go to the case 2. State of Tamil Nadu versus Governor of Tamil Nadu, 2025. The core theme here is governor's inaction, constitutional machinery, Article 200. Very important for your polity and governance, right? So the context is there. Now go back to the static area, cover that part also, because that's very important for prelims. From here, directly question from mains also. So this case is basically dealing with a very contemporary and politically sensitive issue. Whether or can the governor sit on a bill indefinitely without taking any action? Let's start with the facts of the matter or the facts of the case here. See, Tamil Nadu Assembly passed 101 bills and sent them to the governor. For 2 to 3 years, the governor sit on that and take no action. And the state went to the Supreme Court and argued that the governor's inaction was stalling the lawmaking process in the state. And as soon as the case reached Supreme Court, the governor suddenly returned many of these bills, which is actually given to the governor, and the assembly reconsidered, passed them again and sent them back to the governor. Then governor then sent several bills to the president. Again, why this is done? First they returned, right? Second, again the assembly passed it and sent to the government. Now sent to the president, right? So this is doing only for delaying the action. So that created a kind of constitutional deadlock. Now, what are the relevant articles here? Let's understand that also, because if the question is asked, you need to be in a position to quote these articles. Article 200, the governor's options on state bills, right? So 200, you need to go through that. I'll be discussing that anyway. Article 200, clause 1, the president's, his options when bill is reserved to him. And Article 163, that the governor must act on the aid and advice of the Council of Ministers. And Article 142, the Supreme Court's complete justice power. So these are the 4 articles which is coming into picture here. Now let's see what the Supreme Court said or hold. First one, governor cannot keep bills which is pending indefinitely. That's not possible. Indefinite delay is unconstitutional and it is derailing the lawmaking process, right? It disrupts the legislative process also. So it is unconstitutional. It cannot be done. Second, Supreme Court introduced a reasonable timeline. While the constitution, if you see, it doesn't specify a timeline, but the court held that the governor must act within a reasonable period. And the third one, if assembly repasses the bill, governor must have to give his assent. That's normal, right? So after you send to the legislative assembly or the lawmakers and they reconsidered it, and after reconsideration, it is sent again to the governor. Governor cannot withhold the assent again. It have to give the assent, and governor must act on ministry's advice, which comes under Article 163. So he is not free to function independently in ordinary matters. And also Supreme Court invoked Article 142 and granted a deemed assent. And this is historic. The court declared that 10 bills pending for years shall be treated as assented and become law. And this use of Article 142 was unprecedented. Okay, now let's move on to the third case. So the president's reference 2025. So the 14 questions case. Okay. So core theme here is clarifications about the governor's powers after this confusion. So the Tamil Nadu judgment that created some confusion. So the President of India, what happened? President of India invoked Article 143 and sent 14 constitutional questions to the Supreme Court for clarity. So a 5-judge bench heard the reference, and the key clarifications given by the Supreme Court. These are the key, clarifications which has been come out of that, which is again very important for you. So see, first one, court can question the governor's inaction, but cannot impose a rigid timeline. So that's why reasonable time, right? Reasonable time stands, that's there, but there is no such fixed number of days. So here again, reasonable time, that is again very subjective also. Second one, Supreme Court cannot grant deemed assent in future. See, the court cannot substitute the governor or president. So the Tamil Nadu, I just discussed before, deemed assent was given for the 10 bill. So that deemed assent is like one-time exception under Article 142 and will not be a precedent from here onwards. So there is no such, deemed assent will be given by Supreme Court again. Third one, governor is not bound by cabinet's advice in every situation. See, this is again a major clarification. So that the governor is not bound by cabinet advice in every situation. So again, if these questions are asked, the moment you see every situation, that itself will help you to eliminate. So the previous judgment that implied that the governor but the governor has no independent discretion. But this reference gave the clarification that the cabinet's advice is influential, but not binding in all cases. Governor retains discretionary power, right? Again, but these discretionary actions that themselves are generally not open to judicial review. Now, next case. So this is the clarification given. Case 4. Gayatri Balaswamy versus Novasoft Technologies. The core theme here is, can courts modify an arbitral award? See, there is a long-standing confusion which was existed. That was, can a court only set aside an arbitral award, or can it also modify that arbitral award? So under the Arbitration Act, Section 34 is setting aside an award. Section 37, appeal. Section 5, right, under Arbitration Act, minimal court interference. So court, in fact, earlier disagreed. And what did the five bench, judge or five judge bench decide in 2025? See, the courts do have the power to modify arbitral award, but only in limited circumstances. And there are 4 grounds for modification. 1, severability. So that means if one part of the award is invalid but separable, remove that invalid part and save the rest. Second, clerical, typographical, or computational errors. So that means if interest was miscalculated, or if there are typing errors exist, then court may correct that. Third one, correction of post-award interest. If interest is incorrect or missing, that's the case here, then that can be modified. And Article 142, that's a complete justice. Supreme Court may modify to avoid injustice. So that's the power under Article 142. Then the minority view here, that is Justice K.V. Vishwanathan. Courts should not modify awards. Second, arbitration is meant to be fast and final. Third, modifying awards increases judicial interferences. But again, majority view still prevails. So that's the reason why that, it prevail anyway. Now, case 5, last one. Mehnur Fatima versus Vishwesh Infrastructure. So the core theme here is related to Registration Act, property, title, and ownership. So this judgment is incredibly important when it comes to property law. And the key principle here is, a registered sale deed does not guarantee ownership if the seller had no valid title. So you registered a sale deed with someone else, who do not have the, valid title on that, then what's the matter, right? That's the case here. That's the key principle here. So the fact is, the buyer basically purchased 53 acres from Bhavana Society, and they registered the sale deed also. Later, it was discovered that the land had already vested with the state under Land Reforms Act 1975. That means the society had no legal title to sell this land. So the buyers, what they did, they filed petition under Article 226. Now, what did the Supreme Court say? No one can transfer a better title, than they themselves possess. So if the seller have no title, registration does not cure the defeat, right? This is very simple, logical. And the registration is not proof of valid ownership. Registration is a procedural formality. It cannot legalize an illegal or invalid transfer, which is not possible. Just because you have registered doesn't mean that it can validate illegal transfer. Third one, the private agreements to sell state-owned land are illegal. So this is now a state-owned land. So the private agreement, you don't have the valid title, that is in fact illegal. And Article 226 cannot protect a non-existent rights. Very important one. If the buyers had no legal title, fundamental rights cannot be invoked now because there is no right exist, right? And now one more, that's the fifth one, reaffirmation of Section 49 of the Registration Act. Unregistered or invalid sale documents cannot transfer the property rights. So this is in fact, a must remember principle for all competitive exam also. So guys, these 5 judgments from 2025 are not just legal decision. They in fact defined how the state investigate crime, the first one, how governors must function in a constitutional democracy, the boundaries of judicial power, the future of arbitration in India, and what ownership truly means in property law. So when it comes to, UPSC, these cases will strengthen your conceptual foundations and you can code these cases. right? Article 20, 21, 142, 143, 163, 200, related to separation of powers, federalism, rule of law, evidentiary principles. Again, very important. Arbitration reforms may not be that important. Registration and property rights, not that important compared to the first three cases. So you understand this, and understanding these cases will help you to write better answers. And also, when it comes to interview, you can speak very confidently and you can form a deeper understanding of how India's constitutional framework evolved through judicial interpretation. So these five cases, and the part two, I'll discuss few more cases, and with that, we'll complete the most important judgments of 2025. So I hope you got some knowledge and you got some value for the time you spent here. So if you're looking for any mentorship or classes or test series for UPSC, get in touch with us. See you there.